Hello, this is Ben Hitchcock cross-talking to you today. We are going to do the Lanita Tate hearing. We did the findings of fact, part one. Now we're going to do part two, which is the memorandum opinion here. There was 94, something like that, 81 findings of fact, and now in the conclusions of law, we did not win. Let's put it like that. So now we're going to get the judge to explain to us why we didn't win. So let's see what happens. Bam, magic of video. I like it. Let's see. The issues raised at the hearing, were whether the respondent refused to hire the complainant because the complainant opposed a discriminatory practice or because the complainant made a complaint under the Wisconsin Fair Employment Act. The burden of proving rests with the complainant. The complainant did not meet this burden of proof in this proceeding. All right. A claim of retaliation can be proved by indirect or direct method of proof. Complainant must show that she engaged in a statutorily protected activity, she suffered an adverse employment action, and a connection exists between the two. She's certain lurk, but that's the same anywhere. That's direct, okay? So, for example, you've got a direct email saying don't hire this person because she has issues. That might be an example of a causal connection. And then the filing of, here the whole question was going to be who knew what, and was her complaints and her her WIFA protected complaints in the employment file or not? That's what we're going to find out. So let's see, that's the law. A causal connection consists of the evidence showing that a retaliatory motive have played a part in the alleged adverse employment action. The employer can rebut this, okay? If rebut the prima facie case by showing it had a legitimate non-discriminatory reason for the adverse action, the complainant can prevail by showing that the employer's reason is bunk, merely a pretext for the retaliatory conduct. To prove indirect, she can say that 1, she engaged in a statutory protected activity. 2, she met the employer's legitimate expectations, meaning she should have got the job. 3, she suffered an adverse employment action. And 4, she was treated less favorably than those similarly situated who did not engage in statutory protected activity. Okay, so what that basically means is if you can show that, for example, classic example, 2 people get into a fight, an orange person and a blue person. The blue person gets fired, the orange person does not. You can show that everybody's doing their job up until that point. Then that's the indirect method of saying, hey, you didn't say that we don't want any orange people around here or whatever, but we can infer that from the actions. Okay. Pretext means a dishonest explanation, a lie rather than an oddity or an error. The focus on pretext inquiry, is whether the employer's reason is honest, not whether it's accurate. That's fair. Because courts say that they're not trying to act as a super employment tribunal, meaning second guessing whatever the employer's reason. In retaliation cases, that's also true, the employer's motivation is the ultimate issue. It cannot be found that the employer retaliated against an employee for engaging in protected activity without a showing that the employer was aware of the employee's protected activity. And that means the decision maker, the person who ultimately made the decision not to hire her. Okay? If an employer does not know that an employee made a complaint of discrimination, obviously cannot be motivated by such knowledge in the conduct it undertakes. Equal Rights Division is not bound by common or statutory evidence. Rules of evidence, including the hearsay rule. Hearsay evidence cannot be the entire support for a crucial finding of fact. That's also true. Okay. That means anything that basically, she's going to say anything that the complainant just says alone that somebody told me, that doesn't count. Okay. The complainant provided some information about the substance of internal complaints to the MPS Employee Relations Department. Some information. The complainant testified that she filed an internal complaint with MPS Employment Relations on July 26, 2019 about the treatment she experienced with Ms. Ludwig and other supervisors. The complainant alleged that she was being treated differently than the school engineer with which she worked. The complainant also alleged that she was being harassed. The complainant filed a second internal complaint with the Employment Relations Department regarding the discipline she received in October of 2019. Complainant believes she was disciplined because she had filed the internal complaint with the Internal Employment Relations Department in July of 2019 against Carrie Ludwig and other supervisors. In January of 2020, the complainant filed a complaint with the ERD alleging discrimination. Using the direct method of proof, the complainant demonstrated that she engaged in a statutorily protected activity when she filed these complaints and the ERD. Okay. The complainant demonstrated that she suffered an adverse employment action when she was denied hire by MPS. However, the complainant failed to show that there was any causal connection between her filing internal complaints with the Employment Relations Department or her filing an ERD complaint and NPS's decision not to hire the complainant. Specifically, the complainant failed to show that that individuals knew that decided not to hire the complainant. Renee Slotin-Beauchamp and Christina Rothy knew about complainant's protected activity. They were not involved in the internal complaint processes. Okay. The complainant did not discuss her protected activity during her interview with Ms. Slotin-Beauchamp. There was no evidence that Ms. Slotin-Beauchamp or Ms. Rothy were ever informed about the complainant's internal complaints to the Employment Relations Department or to the ERD complaint she filed in January 2020. That is, unless you count the email from Ms. Hoskins saying that they checked her employment file. So, other than that, okay. The complainant testified that she informed that MPS decided not to hire as a food services after reviewing her personnel file. The complainant presented some evidence about the information in her personnel file. The complainant testified that the letter from Attorney Wetzel to the superintendent alleging discrimination was in her personnel file. The complainant also testified that the November 13th letter from Ms. Freiberg related to the complaint against Ms. Ludwig was in her personnel file. However, there was no definite evidence offered at the hearing as to what, if anything, was reviewed in the complainant's personnel file by the decision makers. There's two files. Let's just see what. Those have been amended through the grievance process. The documents were to be removed from the complainant's personnel file but remained in the file. Okay. The complainant asked that the documents removed from her personnel file. The documents were removed from the personnel file. When? Uh-huh. Let's see if this thing is searchable. I don't think it is. It is not. We'll get there. Former facility worker who had issues. There we go. Not selected. Based on her review of her interview results and a review of her file from when she was an employee. Question, okay, she was not provided specific information, and that was all that was provided in the interview notes. She did not have any. Okay. Uh huh. Uh huh. That's right. She didn't say that she looked at it. Through email communications, the complainant questioned Ms. Hoskins. Even if you accept, let's put it like that. Even if you accept this paragraph is true, you would have to. It's kind of hard to accept this paragraph as true in the paragraph that I just read. But we'll see what happens. Ms. Hoskins informed the complainant that the decision not to hire the complainant was based on her interview results and a review of her file from when she was an employee. The complainant questioned Ms. Hoskins what was in her file, noting that the last time she checked her file, it was in good standing. Ms. Hoskins responded that she was not provided specific information, and that was all that was provided in the interview notes. The complainant questioned who wrote the interview notes because the person with which she interviewed informed the complainant that she did well during the interview. Ms. Hoskins reiterated that she did not have any additional information to provide. Okay. So it's the have issues part, and we go up here, and it says it was also noted the complainant was a former facilities worker who had issues. So we looked in the Slot and Beauchamp interview notes, not in there. And the only place, therefore, that can come from is the personnel file. We'll see what no definitive evidence is, just on what she says. Okay. There's no evidence offered that Slot and Beauchamp were ever informed about the complainant's internal complaints, issues, to the Employment Relations Department or that the ERD complaint she filed in January of 2020. Issues. The complainant testified she was informed that the MPS decided not to hire her as a food service assistant after reviewing her personnel. We have an email from that. So we didn't just have testimony, we had an email. So that's okay, there we go. There was no definite evidence of what hearing, what, if anything, what was reviewed in the complainant's personnel file by the decision makers. That's incongruity. Those two things don't match. Whether decision makers were aware of the complainant's protected activity so that there was a motivated by the complainant's protected activity is a crucial finding of fact. As previously noted, a crucial finding of fact cannot be supported by hearsay evidence. There was only evidence offered that decision makers reviewed the complainant's personnel file and were aware of it came from the complainant's hearsay evidence. Just so we're clear, just two reasons why that's not evidence. Number one, an email coming from a party opponent, meaning the defendant, is not in a business record, okay, is not a hearsay because it's a statement of the party opponent. It's also a statement against interest. It's also a regular business record because it's one of their emails that they have. So I don't know how an email from and then testimony from that's I mean, we all saw that. There would have to be no email and there would have to be no testimony from Hoskins. There would only have to be Miss Tate saying, "This is what Hoskins told me," and that's it. That would be hearsay. So, okay, the judge cannot find the decision where aware of the complainant's protected activity and motivated by the complainant's protected activity and testimony alone. So, wow. All right, so we're going to look at that. There's 2.5 more pages to go. We're going to take a pause here, but just look at the question of hearsay. Right, hearsay is an out-of-court statement brought into court for the truth of the matter asserted. And that just means, again, somebody saying, this is what I heard somebody say is the easiest. I mean, it's onomatopoeia. It does explain that there. So it is true here that because of the rules, they can bring in all sorts of evidence, but they can't have a crucial finding of fact be admitted on hearsay. But so now we all need to sort of remember what what the testimony was on Tate. I know that's been a long time, but it's there. So that's what we're going to have to decide here. And do you think that this judge, when they're saying this, wasn't aware of the testimony of Hoskins, wasn't aware of the email? Um, it's she cites it in the record as R12. We can pull that up there, but as far as I know, that that's the issue there. So if there's an email, which I recall, I'm just going off of my recollection, but tell you there's no way that can be hearsay. So you tell me if that judge is just making a mistake, they just got it wrong, there's some other motivation, I don't know. But that does seem pretty basic. It's a business record, there's an email. I thought we just read over that R12 is the number. I'm not checking that now. But you tell me, what do you think is going on there? So, stick with us. We will definitely keep you informed here. Like I said, there's a lot more Tate to go around. We love it when MPS people stick with us because that's what we're here for, and not just Melbourne public schools, but Milwaukee public schools too. So it's the same thing happening all around the world, but we appreciate your time. Thank you.